Second tempo.
Question 11.
Mr. Speaker, Singapore takes a firm stance against money laundering. We recently strengthened our ability to take action against money launderers through the amendments to the Corruption, Drug Trafficking and Other Serious Crimes Confiscation of Benefits Act, passed in Parliament on 19th November 2018. However, in order to prosecute a person who launders proceeds from the sale of drugs or other related activities in an overseas jurisdiction, those acts must be offences in that jurisdiction. This is in line with the international legal principle of dual criminality. Nevertheless, when we are aware of individuals who are involved in such dealings, we pay special attention to them when they come to Singapore.
Second tempo.
So may I confirm that those persons who actually conducted such activity, which is deemed illegal here, but is legal there, right? For them to launder the money over here, we can't do anything against them, right?
Mr. Speaker, what the member said is not quite the case. And perhaps I will take the opportunity to remind members of the House on the set of legislative amendments that we made in November last year and how that has strengthened our position. As I explained in my earlier reply, Singapore needs to observe the principle of dual criminality when dealing with money laundering offences linked to overseas crime. But this has never been the only challenge the prosecutors face. Previously, even after satisfying dual criminality, prosecutors needed to obtain a certificate from the foreign government or a testimony from an expert in that foreign law to fulfill the burden of proof. This can be a very time-consuming process. What we did with the recent legislative amendments is to reduce the burden on the prosecutors by allowing our courts to decide on the basis of evidence presented by the prosecution that an offence has indeed been committed in the overseas jurisdiction. So that requirement of dual criminality must still be satisfied without having to rely on the foreign governments or experts. So this has helped to address the delays that we've encountered in obtaining the certificate in cases in which the foreign government may not act on our request expeditiously or in some cases may not be willing to issue it. And with the amendments, we are therefore able to prosecute the money laundering offences more effectively. But to the very specific question of what if you cannot establish dual criminality? As I said in my earlier reply, if they have the intention to do money laundering, and if they do set foot in Singapore, we will pay special attention to these individuals and do what is necessary to bring them within the law.
Second tempo.
What I want to clarify is that because I noticed that lately there are many countries actually have legalized the sales of certain drugs, which is actually considered illegal in Singapore, right? But in those countries, they have taken a stand. They have allowed, they legalize it. In other words, they allow retails of those drugs, right? But in Singapore, these are definitely prohibited. We were not allowed. So, person as such, dealing in those drugs, which is a license, right? Of course, I will believe that they are not welcome to Singapore but they are okay in their countries. So with regard to that, the proceeds they arrive from there. If they were to bring it to Singapore, how should we treat them? Thank you.
Mr. Speaker, to the member's question, as I explained earlier, the condition of dual criminality must be met in order for the money laundering offence to be established. But they may have other activities, and it's not for us to speculate on what other activities they may be engaged in. We pay attention to them. And if they have done something that is against the law in Singapore, then we will take the necessary action.